We are anonymous. We are not a political party. We are not a corporation. We are not a cable news network owned by billionaires or funded by dark money. We are a decentralized collective bound by one principle: power must answer to the people, and no one, no president, no attorney general, no administration is above the Constitution. And today we're exposing a massive federal court ruling that could derail Donald Trump's attempt to weaponize the Alien Enemies Act in ways this country has not seen in generations. Let's talk about what just happened. Chief Judge James E. Boasberg of the United States District Court for the District of Columbia issued an extraordinary order aimed directly at the Trump administration. After months of defiance, procedural gamesmanship, and what the judge himself described as flagrant violations of due process, Boasberg made it crystal clear the executive branch does not get to ignore the judiciary. It does not get to disappear human beings overseas and then shrug when asked to justify it. And it certainly does not get to tell a federal court to go pound sand. This case centers on 137 human beings. 137 men who insist they are not members of the Venezuelan gang Tren de Aragua, which the Trump administration has labeled a narco-terrorist organization. The government claims national security. It invokes fear. It waves around the Alien Enemies Act, a law passed in 1798. During the presidency of John Adams, originally designed for wartime measures against foreign nationals from enemy states. A law born in the era of muskets and sailing ships is now being wielded in the 21st century to justify rapid deportations without meaningful hearings. According to court filings, the Trump administration had little if any concrete evidence tying many of these men to terrorist activity, yet they were swept up, processed at lightning speed, and deported. Not just deported, sent to a notorious prison in El Salvador known for brutal conditions, and this happened even after Judge Boasberg ordered planes grounded to prevent exactly that outcome. The administration ignored him. Flights continued. The men were transferred out of U.S. jurisdiction, effectively placed beyond the immediate reach of federal courts. If that sounds familiar, it should. After 9/11, the United States wrestled with similar questions about executive power, indefinite detention, and whether the government could hold individuals without due process at places like Guantanamo Bay. In landmark cases such as Rasool versus Bush and Boumediene versus Bush, the Supreme Court ruled that habeas corpus, the fundamental right to challenge unlawful detention, still applies. The Constitution does not stop at the water's edge. And now, more than 2 decades later, we are watching echoes of that battle play out again. Months after deporting these 137 men to El Salvador, the administration quietly transferred many of them to Venezuela. Think about the contradiction. For years, Donald Trump has portrayed Venezuela as a hostile regime, an adversarial state. Yet when it suited his legal strategy, detainees were sent there not because Venezuela was suddenly safe or stable, but because moving them made it harder for U.S. courts to assert oversight. The goal was obvious: distance equals deniability. Judge Boasberg saw through it. In recent hearings, he ordered the government to propose a feasible plan to provide these men with due process, actual hearings, the opportunity to file habeas corpus petitions, the chance to challenge their designation under the Alien Enemies Act. He pointed to Supreme Court precedent in a related case involving a man named Abrego Garcia, who had also been deported to the same Salvadoran prison. In that matter, a federal judge in Maryland ordered that the government facilitate Garcia's return after determining he had been unlawfully removed. The Supreme Court backed that ruling 9-0. Unanimous. Conservative justices, liberal justices. No dissent. Boasberg made it clear he was bound by that precedent. He said, in essence, my hands are tied. The Supreme Court has spoken. Give me a lawful solution. The Department of Justice refused. They filed briefs dismissing the feasibility of returns. They suggested the court lacked authority. They made it known that if he ruled against them, they would appeal. It wasn't subtle. It was a warning shot across the bow of the judiciary. But Boasberg did not flinch. In his written order, he stated that the court had offered the government an opportunity to propose steps to facilitate hearings for these men. The government, apparently uninterested, effectively told the court to pound sand, believing that other courses would be more productive and in line with Supreme Court requirements. The court now orders the government to facilitate the return from third countries of those plaintiffs who so desire. That language is extraordinary. Federal judges are not known for rhetorical fireworks, yet Boasberg openly criticized what he described as the flagrancy of the government's violations of due process. He praised the attorneys from the American Civil Liberties Union for their reasoned and commendable approach. and he refused to allow these 137 men to languish in the solutionless mire proposed by the defendants. He also emphasized something that cuts to the heart of the matter. This entire crisis would never have arisen had the government simply afforded these men their constitutional rights before deporting them. That's the key. Due process is not an inconvenience. It is not a loophole. It is not optional. The Fifth Amendment guarantees that no person, not citizen, not non-citizen, not anyone shall be deprived of life, liberty, or property without due process of law. The word is person, not citizen. Person. What makes this even more disturbing is that, according to representations made in court, many of these 137 men have told the judge they would rather return to the United States, immediately enter immigration custody, and await their day in court than remain in Venezuela. They are willing to be detained lawfully if it means having a hearing. That is how desperate their situation is. And still the Trump administration argues they are owed nothing. At the same time, Attorney General Pam Bondi has publicly declared this presidency the greatest in American history. She has dismissed criticism as partisan hysteria, lashed out at opponents, invoked stock market highs. The Dow over 50,000, the S&P near 7,000, the NASDAQ breaking records as proof that all is well.
He's listed as a co-conspirator.
And we invited you in. This guy has Trump derangement syndrome. He needs to get, you're a failed politician. I find it interesting that she keeps going after President Trump, the greatest president in American history. And if they could maintain their composure. You don't tell me.
No, I did tell you because we saw what you did in the Senate.
You're a lawyer, not even a lawyer.
Committee will be in.
With obsessed with Donald Trump, you have Trump derangement syndrome. All of you who participated in those impeachment hearings against Donald Trump, you all should be apologizing. You sit here and you attack the president, and I am not going to have it. I'm not going to put up with it. The Dow is over 50,000 right now. The S&P at almost 7,000. And the NASDAQ smashing records. Americans' 401ks and retirement savings are booming. That's what we should be talking about.
Trying to intimidate and punish these ladies.
Your time is up.
Forward.
But a booming market does not nullify constitutional obligations. Retirement accounts do not substitute for rule of law. Let's be clear, Judge Boasberg is not a fringe radical. He is widely considered a moderate jurist. He has been nominated to positions by presidents of both parties. He has professional relationships that cross ideological lines, including ties to Chief Justice John Roberts and Justice Brett Kavanaugh. Ethics complaints against him have been dismissed, yet he has been verbally attacked by Donald Trump and allies, smeared as biased, even targeted with calls for impeachment simply for insisting that the Constitution applies. And this isn't the first clash. Boasberg has already initiated criminal contempt proceedings related to the administration's failure to comply with his earlier order to ground the deportation flights. Contempt of court is not a symbolic gesture. It is a declaration that the executive branch has defied a lawful judicial order. If those proceedings resume after appellate review, we could witness an unprecedented confrontation between branches of government. What's happening here is bigger than 137 men. It's about whether the Alien Enemies Act, a relic of the 18th century, can be stretched into a modern tool for mass designation and removal without individualized evidence. Historically, the act has been used sparingly, most infamously during World War II, when it formed part of the legal backdrop for the internment of Japanese nationals and indirectly Japanese Americans. That chapter is now widely regarded as a stain on American history. The Supreme Court's decision in Korematsu versus United States, which upheld internment, was later repudiated. In 2018, the court explicitly declared Korematsu wrong the day it was decided. And yet here we are again, watching broad executive claims of necessity collide with constitutional guarantees. The administration's strategy appears clear. Move fast. Move detainees out of reach. Create fates accompli that courts struggle to unwind. But Boasberg's ruling suggests that strategy may be collapsing. If the government is compelled to facilitate returns and provide hearings, the narrative of unchecked executive power begins to unravel. Each hearing would require evidence. Each case would demand individualized findings. The sweeping label of enemy would no longer suffice. Corporate partisan media has not given this story the sustained attention it deserves. Coverage has been sporadic, diluted, often framed as just another political skirmish. But this is not just politics. It is structural. It is about separation of powers. It is about whether courts can meaningfully check the executive branch when national security is invoked. We are anonymous, and we see the pattern. We saw it after 9/11. We saw it in the expansion of surveillance powers under the Patriot Act. We saw it in indefinite detention debates. Fear becomes the justification, urgency becomes the excuse, and rights become negotiable. This ruling is a line in the sand. Judge Boasberg is effectively saying if you want to call someone an enemy under the Alien Enemies Act, you must prove it. You must provide process. You must allow challenge. You do not get to disappear people and then dare the courts to stop you. The Trump administration's argument, boiled down, is that the executive's determination is sufficient, that once labeled these individuals lose procedural protections, that courts should defer. But deference is not abdication. The judiciary exists precisely to review executive action, especially when liberty is at stake. If the appellate courts uphold Boasberg's order, the implications are enormous. It would reaffirm that even in matters touching foreign policy and immigration areas where presidents traditionally wield broad power, constitutional constraints remain binding. It would reinforce that habeas corpus, sometimes called the Great Writ, cannot be bypassed through geographic maneuvering. And if the Supreme Court is forced to weigh in again, as it did unanimously in the Abrego Garcia case, the stakes will be even higher. Will the court maintain its commitment to due process, or will it carve out new exceptions? This moment demands attention, because today it's 137 Venezuelan men. Tomorrow it could be another group, another designation, another claimed emergency. Once precedent is set that executive labels override hearings, the door opens wider. We are anonymous. We believe sunlight is power. We believe the Constitution is not a partisan document. It is a promise, and promises only endure when defended.